Hello and welcome. Welcome to another episode of the Empowered Immigrant Live. Thank you so much for being here with me today. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And I'm happy to be here with you on this Tuesday morning. It's like a beautiful morning here in the Bay Area. And I hope that you're doing well, and I hope you're thriving even amidst the absolute chaos that is happening in the world of immigration law. And, this is the Empowered Immigrant Live. I am here hoping to empower. And so thank you for being here. Thank you for tuning in. And I hope to be able to answer your questions, be able to empower you and guide you through whatever immigration legal process you are confronting. And so welcome and thank you for being here. My plan today is to talk about what the big, beautiful bill, which is actually quite ugly, what the big, beautiful, ugly bill means for immigration fees. Because fees are going to be just another tool in Trump's toolbox to disempower people and to push people. And I'm sorry for that, but it is what it is, and it's important to acknowledge it for what it is and be aware of it. And so welcome. Thank you for being here. Here at the Empowered Immigrant Live, we're here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right, my name is Otis Landerholm. I am the founding attorney at Landerholm Immigration, A.P.C, where we fight for your American dream. And it's Tuesday. I'm filming this Tuesday morning on the 15th of July, 2025. Our theme today is, what does the big, beautiful bill, which passed on July 4th, what does that mean for immigration fees? And as always, I like to ask the question, do you want to get a green card this year? Do you want to apply for asylum this year, or for a U visa, or for VAWA, or for some kind of immigration benefit? Or are you facing deportation? Do you want help navigating your way through immigration court? Because if so, do those things, all right? And go for it, do it. And I'd love to help you with that in any way that I can, okay? My firm is on a mission to win, not to lose. We are on a mission to win 10,000 immigration cases in the next 10 years, and we would love for your case to be one of them, all right? So thank you to everyone for being here. If you have questions as I'm talking, please send me your questions. I'll do my best to answer them all, okay? Or at least those that we have time for. All right, so I'm going to get right into it, okay? So on July 4th, Trump signed into law the quote-unquote One Big Beautiful Bill Act, which is it's a huge bill. It's a huge law, right? It deals with taxes, and it increases the debt ceiling, right? And it does lots of different, it has lots of different provisions in it. And gives funding for immigration, and it has also other immigration consequences. And so what I want to discuss, not the whole bill, but I want to discuss some of what this bill means for immigration. All right? And of course, the first part of it is the perhaps ugliest part of it. The whole bill is Congress is giving the Trump administration the money that Trump wanted to basically deport everyone that he wants to, right? They now have a large enough budget to carry out the largest deportation machine that has ever existed on U.S. soil, all right? $45 billion is going to ICE. They're opening and building new detention facilities. They're doubling the amount of bed space that are inside those facilities for the purpose of detaining immigrants. All right. There's also money, $3 billion going to the Executive Office of Immigration Review for the purpose of hiring more immigration judges. All right. There's also money going to Border Patrol, the amount of dollars going into federal immigration enforcement is astronomical. Okay, so that's one piece of it. And then the other piece of it is really my purpose for today. And my purpose for today is to let you know about the fees that are going up. And I'll tell you a story, right? So this was passed on July 4th, which was a Friday, and our office was closed, and most businesses in the U.S. were closed because of the federal holiday, the 4th of July. And and this law was signed on that day. All right. So then on Monday, my office had an appeal that was due. Our actual appeal deadline was Tuesday. And we went in to the office thinking that the appeal would cost us $110, which it always used to cost us, all right, as the filing fee. But reading this law, and I was aware that this was part of the law, the fees went up from $110 to $900, all right, to appeal a denied asylum application. So it's like, okay, our asylum appeal deadline was happening, and these new fees were in effect, but the online credit card processing to make your payment to file the appeal was not updated yet, all right? And so what do we have to do? So we prepared everything. We had it ready to go. We knew that they were working on updating it. The system was updated by Tuesday, so then we uploaded the system. We did not miss our filing deadline. But it's like some of these things you gotta be quick to pivot, because the current administration, they're making decisions like this, and they're not saying, okay, this will go into effect next month. They're saying effective immediately, the fees are going up. Well, there's no time even for the government's own agencies to react that fast. They did, to their credit, they got it up within 48 hours, but it wasn't, there are people that could have lost their deadline on that Monday trying to upload an appeal. So it's crazy situation. Morito, I see your question there. My name is Otis Landerholm, all right? And I am the founding attorney here at Landerholm Immigration A.P.C. We're a law firm based in Oakland, California, and we fight for the rights of immigrants, all right? I'm a certified specialist in immigration nationality law, and I run a really awesome law firm that fights for the rights of immigrants who are facing deportation. And it's an honor to be here with you today. All right, so let's talk about these fees. All right, let's talk about the fees that have been included in this bill. And I disagree with all of them, but that's not the purpose of this video, right? The purpose of this video is to share what they are. So the first is the asylum application fee. So for the first time in history, they are requiring a fee for the filing of the I-589, for the filing of asylum. It's $100 for now, subject to an increase with inflation, indexed for inflation, and it'll go up every year. And it's an annual fee. All right, so for each calendar year that an asylum application remains pending, there will be an additional $100 fee subject to increase based on inflation. Okay, so I have some asylum cases that have been pending since 2015, and so that's a 10-year delay right now, so that'd be $1,000, $100 a year for the 10 years. So the next fee is the requirements the EAD based on asylum. So when an asylum seeker files for their first work permit, EAD stands for Employment Authorization Document, your work permit, then you have a fee for that work permit, that card to be issued, of $550. Okay, that's the first time you do it. And in addition to the annual asylum fee, The next fee is the renewal of your work permit. So $550 is the initial first time asylum work permit. When you renew the work permit, it's an additional fee of $275 every time you renew the work permit. Okay? All right. Next is the appeal fee. The immigration, when you appeal the decision of an immigration judge, I mentioned that in my earlier today, that has gone up from $110 to $900. Also will increase with inflation, be reassessed each year. Okay? Similarly, a motion to reopen or a motion to reconsider, the fee has gone up from $110 to $900. And then there's two other fees that are brand new, that are ugly, and that I'll share right now. The first is what we call a in absentia order fee. Says that if someone is ordered removed and they didn't show up, they're ordered removed because they didn't show up to their hearing, all right? And if they're subsequently arrested by ICE, they trigger a $5,000 fee for their failure to show up to immigration court. A $5,000 in absentia removal order fee that's never existed before. And there's no fee waiver of it, and it will go up indexed to inflation. All right? And the final one is the inadmissible alien apprehension fee. And this says that if a person is apprehended between ports of entry and they're inadmissible, then $5,000, they'll be charged a $5,000 fee. All right? And that's where that's where I'm going to stop. But that's the crux of it, okay? And I wanted to communicate all of that. Lots of fees, making it ever more difficult, ever more complicated, ever more challenging to request asylum in the United States. And in my view, it is a breach of our duty. It's like asylum's a humanitarian right, all right? And it was passed under international law, the 1951 Geneva Convention on the Status of the Refugees after World War II. And it's like if human beings are fleeing for their lives from countries where their life is in danger, subject to persecution, violence, death threats, etc., charging them money to request and to file for a law that is their human right to request is ugly. All right? And that's my own political stance. And that is my political stance, right? People should not have to pay dollars for something that is their own human right. No human being should be persecuted, tortured, subject to serious violence because of who they are. And they shouldn't have to pay to leave that, right? That should be an obligation from the state of a country to welcome human beings who are in that situation. And that's actually international law, folks. And so the extent of which each of these fees potentially violates or conflicts with international law and with our obligations under the 1951 Geneva Convention on the Status of Refugees, like that's going to be an interesting argument, right? And we're going to see many of these might very well be challenged under the grounds of that treaty. Now, it's a tricky argument because arguably the treaty is talking about something called withholding of removal instead of something called asylum, which is a separate term passed under statutory provisions inside of the Immigration and Nationality Act. So there's tricky legal arguments at play. Nevertheless, the fundamentals are that when a person is fleeing for their life to a new country, my view says they should not have to pay dollars, money, in exchange for their own human right to live safely. All right? Anyway, Thank you for tuning in. That's what I wanted to share today. Really appreciate each of you for being here. Again, my name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And now let me answer your questions. What questions do you have today? And yes, APLL 1N4R. Yes, I do speak Spanish. Sí, hablo español. I will be doing this exact same session in Spanish here after we're done here in English. Okay, so venga nuestro episodio en español, no hay problema. All right. All right, so Maria Girl USA. Maria Girl USA. I see your question. What is needed for a work permit? All right, so to be eligible for a work permit, you have to have an underlying application pending. All right, and you've got to show that that underlying application is pending. And there are some other requirements. If it's an asylum case, you can't have certain criminal convictions against you. All right, you've got to have 2 passport-style photographs that you submit with your application, and it's got to be pending. And you can apply for a work permit. Certain applications give you the right to request a work authorization document. Other applications don't. Okay? And so, like for example, when you apply, this is maybe a bad example because we can't apply newly right now, but for example, if you apply for DACA, right, you can get a work permit once your application's approved, but you cannot get a work permit when the application is pending. Versus when you apply for a green card, you can apply for a work permit that can be approved while your case is still pending. And then after your case is approved, then you'll be mailed a green card. Okay, but you can get a work permit while that case is pending. Anyway, hope that answers your question, Maria. Thank you for being here. Kathy Sanchez, your question is, and hello and welcome. Your question is, I have a question. My husband is on removal processes, appealing in court. He just got his residence card through another position, but OPLA, the Office of the Principal Legal Advisor for ICE, OPLA doesn't want to dismiss his case. I've already sent evidence. What can I do? Well, Kathy, thank you for being here, and thank you for asking that question. So if your husband has won his green card, then I don't care what OPLA does or doesn't want to do. You need to submit that motion to terminate in front of the judge. And if the judge fails or doesn't dismiss and doesn't terminate your case, you should appeal that decision. Because if your husband has a green card, and if that green card was lawfully issued, then your husband is no longer deportable. Okay? And so, OPLA, they can be jerks, folks. They can, under Biden, they had better direction, but they've got to follow the protocols of the Department of Homeland Security. And right now, leadership in the Department of Homeland Security, they are not amenable to doing things that are rational, right? They are being jerks, just to say it like it is. And so you got to understand that. I don't mean to insult any one person, but the department as a whole, they're being jerks. All right? They're not negotiating, they're not being reasonable at all in immigration cases, which means that you got to prepare for that. And when you file your motion, you file it not to them, you file it to the judge. And if the judge appeals, then the judge is getting it wrong. If the judge denies it, then the judge is getting it wrong, and you've got to appeal that thing. But you got to do a good job in your motion to terminate so that if the judge gets it wrong, you have good grounds. You've made your good arguments, and you can appeal. Okay? All right. My next question. So, Efren Martinez, you say, good morning. Do you think if the DUI bill goes into law, you think it will be retroactive? Okay, that's a very difficult thing to predict. All right, that's a very difficult thing to know at this stage of the game because they're still going through the process. And it will be ugly if they try to apply it retroactively. There's like nobody should take a plea. If somebody accepts a plea deal, right, when they're going through a criminal process, thinking that the immigration consequences are X, and then they change the immigration consequences later to apply retroactively, well, people should never have taken that plea deal then. And so it's like it becomes a very messy situation. It should not be allowed to apply retroactively, and they're going to try. All right, they're going to try. And so thank you for sharing that question. And yeah, and just to be clear, the latest DUI bill makes a DUI a inadmissible conviction, a criminal conviction that causes inadmissibility, and it is waivable on the I-601, just like 212H waiver, but that's a big change that would have huge ramifications. And because there's a lot of people that have a DUI conviction from the past. And so, Efren Martinez, thank you for asking that question. Really appreciate it. And stay tuned, right? I'll be doing episodes about that if it continues to go through the legislative process. All right. My next question comes from 444. You say, me and my husband put in an I-130 petition. Do you know how long the process will take? Okay, so are you or your husband a U.S. citizen or a green card holder? Because the processing times are different depending on whether the spouse is a U.S. citizen or a green card holder. U.S. citizens right now, anywhere from 8 months to 2 years, right? And that's a long variance. That's a big variance. It's typically 8 months if you have a straightforward, you have kids together, you have a very well-documented relationship. Typically 2 years is if they need to interview you. And so they'll schedule you for an interview, they'll talk to you about your relationship, and then approve the I-130 only if you have evidence of the bona fides of your relationship. And so, approximately that. Okay? So then, Mohammed, have you ever filed an I-508 or an I-566? I don't know. Let me refresh my memory. An I-508 is a waiver of certain rights, diplomatic rights or privileges for diplomats. No, I don't think I've done that. But a couple of the attorneys on my team have worked on diplomat cases. So it's possible that my office has, but I myself, I don't think I have done that. And I-566, let me see. An I-566, an A visa, a G visa, or a NATO-dependent employment authorization. Okay, so me personally, no, I have not. Mohammed is the answer to your question. All right, but thank you for asking it. Let's see, Geeky, the English teacher. My boyfriend is convinced that getting married is going to make his immigration longer versus asylum. Well, great. Your boyfriend can be convinced of a lot of things, but that doesn't mean that he's correct. And I don't know if he's an immigration lawyer. There's lawyers that get this incorrect, And so the wisest thing is if you and your boyfriend have a disagreement about that, you might recommend that you both go in with all of your questions and talk to an immigration lawyer. All right? In my experience, marriage to a U.S. citizen, for example, is much quicker and easier than going through an asylum process if your boyfriend entered with permission, with a visa, with parole, right? If your boyfriend entered without permission, then, asylum still can take years, all right? I have many asylum cases that are backlogged and that will take a really, really, really long time. But it's tricky if a person entered without permission, or depending on their background, right? They might not be eligible for a marriage-based process, but they might be eligible for asylum. And so there's lots to go into. Like your boyfriend might not be wrong, but he might be. And so it's often a wise thing to first have a consultation, bring all your questions, bring your boyfriend's, come in, let's talk it all together. And, and there might be a human thing going on as well. Like maybe your boyfriend is hesitant for whatever reason to want to get married, right? For whatever reason. And that I think that is possible. And that also might be, how can I say this? I'm married. I love my wife. We have kids. I love marriage. I love like being married. It's a great thing, right? But not everyone feels that way. And so, and especially, I know a lot of clients that it's like, oh, I want to get my immigration issues sorted out before doing that. And like, I get that. On the other hand, sometimes going through the legal act of getting married and making that commitment to another person and having it be authentic, right, shows something and gives someone additional options within immigration. Not all the time, right? Some people are not eligible to adjust status through marriage, ever. They're inadmissible, right? Other people, they can do that. So anyway, those are my 2 cents there. Geeky, the English teacher, and thank you for being here. All right, Mohammed, you ask, I was a victim of domestic violence last year, tried to fix the marriage, but unfortunately the abuse is still on. Got it. Sorry to hear that. I'm sorry to hear that. Yeah, don't tolerate being in a toxic situation, all right? Everything that I just said about marriage, it only works if it's a healthy one, right? Like no one should tolerate being abused. And it's hard, I think, when people are in that situation. So Mohammed, best of luck to you. You know, you're not alone with that. You're not alone. And I've met with hundreds and hundreds of people who are very, very nervous and going through anyway, I just want you to know that it can be very, very scary to leave a relationship when, especially if it's a U.S. citizen or a green card holder, when they are the one that might be able to fix your immigration status. And there are laws that can protect and actually give people that do leave or that are in that situation some options, okay? And so I would recommend talking it through with an immigration lawyer, and let's see how we can do, let's see what we can do to potentially use that situation to, one, get you out of a toxic situation so that you can move on with your life, but two, to help you with your immigration situation at the same time. All right, so Larissa Sandoval 98, you say, hello, hi. I just got my work permit. How long do you think it's going to take to get the green card? Well, it depends on the type of green card process that you're in, and it depends on if you're married to a U.S. citizen or a green card holder. But if you're going through a marriage-based adjustment of status, if you entered with a visa, if you're married to a U.S. citizen and you're getting a green card or getting a work permit as part of the process, you know, in my experience, you file a case, 5 to 7 months go by, you get your work permit if it was done well and properly. Then another 8 months or so or less, you get scheduled for your interview, and then about a month after that, you get your green card. Right? If it's a smooth sailing process, that's about the timeline. Takes, you know, a year to a little over a year, typically right now, to get a green card approved through a straightforward marriage-based process. All right. Click, you ask, how long does a joint motion take in Texas? A joint motion to do what? A joint motion to reopen? Like joint motions, in my experience, are just not working. All right, so joint motions, remember, are when an immigrant and the Department of Homeland Security, kind of like the bad guys in immigration court, join together and ask the judge to do something. So under Biden, we would get joint motions to reopen. They would join our motions frequently because they were more amenable to making rational decisions in immigration court. But right now, I don't see it happening, right? So click, if you get a motion to reopen or another motion joined by the Department of Homeland Security, please let me know. I'd love to hear about it, right? But that's not been my experience, and I don't think it's happening. All right, except on very unusual situations. All right, reporter, your question. Is it true that they are denaturalizing people? Yeah, they are pushing to start denaturalizing people. That's not an automatic process. All right, they've got to file a federal court complaint and allege that somebody got their naturalization through fraud. All right, and then that starts a fight in federal court. And so, yes, they are going to be pushing denaturalization. But it's a big process. If anybody's receiving that type of notice, federal complaint, you need to talk to an immigration lawyer that has experience working in federal court. Okay? Larissa Sandoval, you say, if they already interviewed me in Juarez for a K-1 visa, do you think it's going to be a second interview? Yes, they will interview you again. All right, no question. Yes, they will. All right, Hamid, I applied for an I-485 and an I-130 for your green card. It's a marriage-based. After 2 months, I got an interview. It's for the I-130 and I-485. So you're on a fast track. That's awesome. Yeah, I've seen that also, and that's different by different field offices, but that should be great, right? As long as you're eligible, as long as everything looks good, go to that interview, win your green card. Congrats to you. All right, make sure. I would really recommend having an attorney go with you, but overall, it sounds like you've got a smooth sailing process, and I wish you the best of luck. All right. Okay, Geeky, the English teacher, you say, ha, thank you. He's happy to get married. He's already said it. Okay, he just needs to feel safe here too. I mean, so great. Have him talk to an immigration lawyer then and bring all of his concerns about filing a marriage-based case. Because if he loves you, he wants to get married to you, he wants to form a life with you, that could maybe, and if he's got an asylum case pending, a marriage-based case can be way faster than the asylum case, and it's wise to get married before an asylum case gets denied because the standards of a marriage-based case go up if you marry after a person's already in removal proceedings. And so there's lots of strategy at play for him. And so I would just recommend that the both of you meet with an immigration lawyer, talk it through, and we could help you strategize that. All right, feel free to give our office a call. If we could help you with that, we'd love to. All right, so let's see. Maria Girl USA, I-130 approved. Can you get a work permit before the hardship waiver? No, you can't. Thank you for asking this. I-130 approval, a petition approval, does not convey work permit authorization. All right, you're not in status yet when an I-130 is approved. So if you're going for the consular process, it's I-130, then the waiver, then the consular process. Once the consular process is done and approved, then a person can enter, get a green card, get their work permit. Get their green card, really. It becomes their work permit. So I hope that is clear, and I hope that I correctly interpreted the process that you're going through. Okay, because it sounds like your husband is not eligible for adjustment, although you might clarify that with an attorney if you have questions about that. Okay, let's see here. Maria Lacerda, you say, I heard there's no more bonds. What people with only U visas, bona fide letters, can do if they get arrested by ICE? Great question. It's not that there are no more bonds. It's that ICE guidance for who's eligible for bonds has changed. And I'm going to do an episode on this because it is very ugly. They're basically alleging that anyone who entered the country without authorization is no longer eligible for bond. That's what ICE is arguing. That doesn't mean the judge agrees with ICE, but that's what ICE is arguing, which is horrible, right? And so the question then is, what do people with a U visa do if they're arrested? Well, you got to fight something other than a U visa, because immigration court can't approve a U visa. All right, so you might need to apply for cancellation of removal. You might need to apply for asylum. You might need to apply for something else in front of the immigration judge, especially if they won't bond the person out. Okay? Mike BRO, you say, hello, sir. Did you ever win cancellation of removal? How hard is it? Hundreds. I've won hundreds of cancellation of removal cases. How hard is it? It depends on the judge. It depends on the facts of the case. It depends on which type of cancellation of removal you're doing. All right? Cancellation of removal basically is 4 different types of things. All right? There's LPR cancellation, which means if you're a green card holder, you've been put into immigration court proceedings typically because of crimes. All right? You can apply to have your removal proceedings canceled. All right, and there's certain requirements. You can't have an aggravated felony. You've got to have certain amounts of time in the U.S., at least 5 years with your green card, at least 7 years before the conviction of any certain offense. The second type of cancellation is called non-LPR cancellation. We call this an E42B case because that's the form that you use to file this type of case. There you've got to show 10 years of physical presence in the U.S. You've got to show 10 years of good moral character. And you've got to show you have a U.S. citizen or a green card holding spouse, parent, or child who would suffer exceptional and extremely unusual hardship if you were deported. Okay? The third type of cancellation is under an old law. We call it suspension of deportation. It's for old cases. And the last type is also under an old law. We call it NACARA. All right? NACARA-based cancellation of removal. There's actually kind of another one under VAWA. All right, so VAWA-based cancellation. So that's actually 5. There's actually, now that I'm thinking about it, there's actually a 6th called 212C, which doesn't exist anymore. But I've got one 212C case. If you have old crimes and you used to have a green card from before 1996, talk to somebody who's really good, like me. Talk to somebody like me. Who's done 212C before. I'm just throwing it out there, right? And yeah, you know, it is possible to waive certain old criminal convictions. Anyway, so Mike BRO, that's the answer to your question. Yes, it's possible to win cancellation. How hard? It depends on which type of cancellation and the facts of your situation and which judge you have. All right? So user 335555, you say, divorced twice while still getting a green card. Is that going to affect my citizenship in 2 years? Yes, you know, it probably will. The question there becomes, did you get your green card through one of those marriages? Because if you got your green card through the marriage, you had to show that your marriage was bona fide in good faith. And if you're divorced, then they'll probably just ask you a lot of questions about that. It doesn't mean they're going to deny you, but they'll probably ask you a lot of questions about that. All right. Pope Joyce, you say, good day, sir. I have an appointment with you tomorrow afternoon. All right. Well, thank you. Look forward to seeing you. Okay? All right. Those are all the questions I got today. Thank you all so much for being here. All right. Thank you for being here. Really appreciate your taking some time out of your day to tune in, to understand what's going on in the world of immigration law, and to, you know, like, let's connect and let's be empowered here. All right. So thank you all so much for tuning in. Really appreciate each of you, and yeah, let's stop there. And thank you so much. If this was useful, if this was helpful, please take a moment, go to our channel in YouTube, and hit the subscribe button. All right. Subscribe to our channel on YouTube. When you're there, if you hit the notification bell, you can be notified whenever we upload an additional video with updates, with news, with announcements, things of that nature. And yeah, if this was helpful, please always tune in, come back, and join us on our next episode of the Empowered Immigrant Live. Thanks a lot, everyone. Make it a great day. Take care.